Hi, everyone. I'm Maggie McGrath, senior editor at Forbes and editor of ForbesWomen. The Trump administration this week rescinded a policy from the Biden administration that effectively protected pregnant people in emergency medical situations. This rescinding leaves open a ton of questions for pregnant patients and what it means for their care in emergency settings. Joining me to discuss this very important issue is Katie O'Connor. She is the Senior Director of Federal Abortion Policy at the National Women's Law Center. Katie, thank you so much for joining us.
Thanks for having me, Maggie.
So I was speaking in very broad terms because when it comes to EMTALA, the specifications can get a little complicated, but can you lay out for us what did federal policy say before this week and what is the Trump administration saying now when it comes to pregnant patients who enter an emergency room and might require emergency abortion care?
Yeah, so this all started, well, I should start with saying, EMTALA is a 40-year-old law. It was passed by an overwhelmingly bipartisan majority. It has been understood for all of its history to protect everybody who goes into an emergency room needing emergency care, or needing stabilizing care. And that has never been understood to exclude pregnant people. So there's a wealth of examples of pregnant people going into emergency rooms receiving this care because of EMTALA. Um, in the immediate aftermath of the Dobbs decision overturning Roe versus Wade, the Biden administration issued guidance, and all that guidance did was reminded hospitals of their existing obligations under EMTALA, reminding them that even if there's an abortion ban in the state, EMTALA is a federal law that preempts state law and that requires emergency abortion care where that is the necessary stabilizing care. So what we saw on Tuesday was this administration rescind that guidance. But I think the one thing I want everybody to understand is that this administration can rescind the guidance, but it can't change the underlying law. And so EMTALA, the underlying law, continues to protect people's right to get this care where it's the necessary stabilizing care.
I think that's a really important point. And can we just go into a potential situation, an anecdote, a hypothetical anecdote for when a situation would require an emergency abortion? So it's a patient who is pregnant with a wanted pregnancy, but she experiences some kind of medical emergency, and doctors make the recommendation that to preserve her life, there needs to be an abortion. Is that kind of the general, very broad hypothetical proceeding here?
That's correct, with one caveat. So most of the abortion bans in the states that ban abortion do have exceptions that vary in sort of their narrowness. They're all pretty narrow, but some of them allow abortions in the case where it's needed to preserve a person's health. And then in some states, like Idaho, for example, the only exception is to prevent the death of the pregnant person. EMTALA is important because it actually protects access to abortion care where it is necessary to preserve a person's health. So it's broader than just life-saving care. It is also to ensure that a person's health doesn't deteriorate.
That's an important distinction. And now you mentioned some of the state by state differences. And I think this is important to hit on because folks who've been paying close attention to this might remember that we were talking about EMTALA last year as it related to state specific Supreme Court cases. Katie, can you take us through where we stood on a state by state basis? And was EMTALA overridden in any one state before this week?
That is a tricky question. So there have been a couple of cases that were filed since the Dobbs decision. One of the cases was actually filed by the Biden administration against the state of Texas. And the Biden administration said, your abortion ban is too narrow. There are cases where EMTALA would require a doctor to provide an emergency abortion, and your state abortion ban would prohibit that care. And so the Biden administration said where those two laws conflicts, EMTALA overrules the state law, and that's the case that the Biden administration was litigating. As you might remember, a couple of months ago, the Trump administration decided to drop that case. Um, In the meantime, there is a large healthcare provider in Idaho called St. Luke's. It is the top healthcare provider in the state. It filed its own lawsuit, essentially like following up with what the Biden administration had done in its lawsuit. That case is pretty slow moving, but it will eventually make it to the Supreme Court. The other case that I will mention is a case in Texas where the state of Texas filed suit against the Department of Health and Human Services, challenging the guidance itself. The Fifth Circuit actually ruled in favor of the state of Texas. And so the guidance is not in effect in Texas. But as I said earlier in this interview, the guidance doesn't really matter because the statute itself requires this care. So all of these cases are ultimately just contributing to the confusion that hospitals and providers and patients are experiencing and have been experiencing since the Dobbs decision.
So effectively, we have a federal guidance saying doctors must provide life-saving, life-preserving care for patients. If that patient is pregnant and if that life-preserving care does involve an abortion, those doctors need to perform the abortion whether or not the state that they're in is quibbling over the matter. Is that kind of fair?
That's right. It's essentially, our constitutional system works as under the supremacy clause, like the federal statutes are supreme to state statutes, and so what the federal law says is what goes, and that's what the Biden guidance had indicated, and it is the fights over this that are contributing to the confusion and fear, honestly.
And that's why I'm pressing on the specifics of the law, because I think when individual people see these headlines, hear these headlines, they might not know what it means for them. So, what are you hearing at the National Women's Law Center? Are patients confused? Are they calling saying, I don't know what to do? What do I say to my doctor? Or what are the conversations you've been having this week?
I think people are still waiting to see what the fallout from the rescission of this guidance is going to be perfectly honest. You have a lot of nationwide organizations that represent emergency healthcare providers, that represent um, obstetricians and gynecologists, that represent other healthcare systems. And I think they are all sorting through what this is ultimately going to mean. And so I unfortunately don't have a lot of a lot of intel on that, other than to say, again, this is a shift. And you know, it has just been 3 years since Dobbs, and it's been a constantly shifting legal landscape in a lot of states around what care is required, what care is allowed, and what care is prohibited. And what happened this week is just contributing to that shifting legal landscape.
How much of a surprise was this week's announcement to you, at least? Because I have to say, from the Trump administration, given all the focus on tariffs and some of the other issues that have been in the headlines, I was surprised to see EMTALA pop up when it did. But had there been inklings that they were about to come out with this?
There had been, and this is primarily because there was another lawsuit that was filed in January of this year in the Middle District of Tennessee, so in a federal court in Tennessee. And it was filed by an organization called the Catholic Medical Association. And that lawsuit was also a challenge to the Biden administration's guidance on EMTALA. So we knew that there was a deadline coming up for the Trump administration to respond to that lawsuit, and that sort of forced their hand here. I agree with you that it's kind of a weird time, and that there's a lot of other political news happening, but that was what forced the Trump administration to do this when it did it.
A lot of political news, but let's be clear, this is important because it affects people's lives. Can you give a sense for what the repercussions of this announcement could be if it stands, if somehow EMTALA ceases to be the federal guidance?
Yeah. So again, I mean, I I hope and trust that hospitals are going to understand that the statute itself, that EMTALA hasn't changed, and that um, this is just a rescission of guidance that reminded hospitals of their obligation. I think what is most likely to happen, this is probably a sign that this administration isn't going to enforce EMTALA the way that the past administration did, and frankly, the way that past administrations for decades have done. So I think that's probably the concrete effect here is we're just not going to see as many enforcement actions.
And what could be the follow-on for patient care? Will people die?
Yes, I think people will suffer unnecessarily and some will die because of the confusion that is caused by what the Trump administration has done this week.
What are the steps forward, the perhaps ways that your organization and other national women's reproductive health care organizations are perhaps fighting this or trying to soften some of the confusion? I recognize that in the years since the Dobbs decision came down, that legal landscape that you laid out state by state, it can be very confusing. But what are the concrete steps that you and others will be taking in the aftermath of the Trump administration's announcement this week?
Well, I think a couple of things are going to happen. First of all, I mentioned a lawsuit that is still being litigated in Idaho. That lawsuit will take a while to get to the Supreme Court, but I do think it'll get to the Supreme Court and probably in the next couple of years. That lawsuit will hopefully provide the clarity that we all need. And we would hope and expect for the Supreme Court to say unequivocally that EMTALA requires providers to provide abortion care where it is the necessary care for a person who's experiencing a medical emergency. Until the Supreme Court says that and says that explicitly, I think we will continue to see a lot of fear and a lot of confusion in emergency rooms across the country. But I do hope and expect that hospitals will look at what happened this week and recognize that it doesn't change their legal obligations, that it is only a signal of the priorities of this administration, which is obviously appalling that this administration is abandoning pregnant people when they're in need of emergency care. But again, it doesn't change the underlying law here.
I think that's an important note. It's effectively a political message, not a medical message.
That's right.
Is there anything else our Forbes audience should know and understand about this week's Trump administration announcement regarding guidance around emergency abortion care in the United States?
I don't think I have anything to add. I would just, I am very disappointed that this happened. I am also not surprised. Something that I continue to think about is that we are just shy of 3 years out from the overturning of Roe versus Wade. It has been clear to me and to most people who do this work for a long time that the anti-abortion movement was never going to be content with overturning Roe versus Wade. It was never going to stop until abortion is prohibited everywhere for everyone and under every circumstance. And I'm just surprised that it has only taken 3 years for us to get to this point where pregnant people are, begging for their lives.
Sobering words. Katie O'Connor from the National Women's Law Center, thank you so much for joining us. We'll have to have you back as we continue to follow this issue, but for the meantime, thank you so much.
Thank you.